Okay. Let's go ahead then and call the case. Plaza Court versus BAKER-CHAPUT.
May it please the Court, Amanda Chapman for Appellant, Plaza Court LP. This was a interstate land sales case filed in the lower court by the plaintiffs BAKER-CHAPUT and Christine O'Brien. I'd like to emphasize briefly a few of the pertinent facts because this interstate land sales case is slightly different than other interstate land sales cases that you may have seen in the past because we are not dealing with similarly situated plaintiffs here. Early in 2005, Mr. Baker approached Ms. O'Brien and asked her to join him in investing in a pre-construction unit of a condominium at a project known as the Solaire in downtown Orlando. At that time, Mr. Baker asked Ms. O'Brien to split the purchase with him, and she agreed to do so. At that time, she believed that she signed the purchase agreement at that time, and she also gave him in excess of $22,000, representing her half of the down payment. That was in early 2005. Ms. O'Brien heard nothing until 2007, early 2007, when she took it upon herself to contact Plaza Court, the developer of the Solaire, and ask about the status of the construction of the unit. At that time, this is again almost 2 years later, she learned that not only was she not on the purchase agreement for the unit, but that the unit had been completed, construction was done. Certificate of occupancy issued in February 2007. Ms. O'Brien then confronted Mr. Baker about why she was not on the purchase agreement. Whatever explanation he gave her, she accepted it, and he offered to add her to the purchase by way of a special addendum. And she actually signed that special addendum in April 2007, adding her to the purchase. 3 months later, July 2007, Mr. Baker decides he wants to revoke the contract, and he sends Plaza Court a notice revoking or rescinding the agreement for some unspecified violation of the Interstate Land Sales Act. There was no mention in that notice of Christine O'Brien. He wrote that letter on behalf of himself with absolutely no mention of her, no indication that she even knew about the letter. Plaza Court refused to rescind the agreement, and in October of 2007, Mr. Baker filed a lawsuit against Plaza Court citing violations of the Interstate Land Sales Act. Again, Ms. O'Brien had no idea that the lawsuit was going on, except she does state in her deposition testimony that she gave $500 for some legal fees for perhaps a legal proceeding, but she was not kept apprised of the legal proceeding, and she was not added as a plaintiff in the legal proceeding. She was not added until January of 2008, several months later, only upon the urging of Plaza Court that she was an indispensable party to the lawsuit because of the special addendum, which added her to the purchase of the unit. The lower court ultimately found that Plaza Court was subject to the Interstate Land Sales Act, that they were not exempt, and that Mr. Baker and that Ms. O'Brien timely filed their action under the Interstate Land Sales Act. Now, at this point, I want to focus a little bit on Ms. O'Brien because here we're dealing with the two not similarly situated plaintiffs. Ms. O'Brien is not subject to the Act at all. First of all, Ms. O'Brien, when she was added by way of special addendum to the purchase in April 2007, the condominium had already been constructed. Section 1702 of the Interstate...
And the appellee's argument is that it relates back.
Yes, sir, I understand that. But my first point on this is that by the time of April 2007, when she was added to the purchase, the unit had been constructed. Section 1702 of the Interstate Land Sales Act provides that there is that a constructed unit or improved property is not subject to the Act. And the purpose behind the act was always to protect people from unscrupulous schemes by developers to sell property not suitable to be developed and property often sight unseen by people. We don't have that in this case. When Ms. O'Brien was added to the special addendum in April 2007, she had every opportunity to go see the Solaire, the entire project, to walk through the unit, to see the amenities, to see the entire project. This act was simply not intended to apply to anyone like her. But if, as appellees urge, that the addendum relates back and she for some reason is found to be subject to the act, well then we are left with the fact that she never rescinded the purchase agreement. Mr. O'Brien sent his revocation to Plaza Court on July 31st, 2007. There was no mention of Ms. O'Brien.
She's also alleging that the 2-year completion within the contract was illusory, is she not?
That's correct. They absolutely are. But an analysis of that becomes unnecessary because whether or not she is, even if she is covered by the act, they were barred by the statute of limitations. That brings me to my next argument. If we turn to Mr. BAKER-CHAPUT at this point, there has been very recent case law discussing the interplay between Section 1703C and Section 1711B in the Interstate Land Sales Act. Section 1703C provides that if a property report is not given and it is required, the purchaser has 2 years to revoke the purchase agreement. Section 1711 provides that provides a 3-year statute of limitations for 1703 violations. There's been quite a bit of case law very recently discussing the interplay between those two sections. Most recently is Midas versus Park Square Enterprises, Inc., which is a December 17, 2008 Middle District of Florida case.
Is that Conway case?
It's regarding a house in Orange County.
The judge is someone named Conway?
Oh, yes, sir. Yes, sir. The opinion was written by Judge Conway. In that case, the court followed Taylor versus Holiday Isle, which is a Southern District of Alabama case, and also followed Dithart versus North Ocean Condos, which is a Southern District of Florida case on July 11, 2008. The holding in each of those cases is that a revocation under Section 1703C is an absolute prerequisite to being able to file a lawsuit within the 3-year time period provided by Section 1711. If you fail to, the Midas case also goes into detail by saying that if you fail to exercise your right of rescission within that 2 years, you cannot again revive your claim by simply filing suit within that 3rd year. You must revoke within the 2 years. Any other interpretation of these sections would render 1703C meaningless if you were not to require purchasers to revoke within that 2-year period, would to read it completely out of the Act altogether. And that's something that, again, the Midas case, the Taylor versus Holiday Isle.
Your position is that if you don't file for rescission within the 2 years, that assuming that we were to find the language in the contract as to the 2-year completion date to be illusory, your position is that it doesn't matter, you don't get to that point because there was no rescission within 2 years, and so what are the damages for the illusory nature of that contract?
You're exactly right. That is exactly my position, Your Honor, that they must serve a notice of rescission within the 2 years. It doesn't have to be a suit, just simply the service of some sort of a notice of rescission. And the cases haven't even really come down on the question of whether or not it has to be a written revocation. Just some notice of revocation of the agreement within 2 years. And then you have that extra 3rd year in which to file a lawsuit. And that's also supported by the legislative history. And turning to your question, what are the damages for the illusory If they did not revoke, but the contract is found to be illusory, we'll say even if they are not entitled to the revocation under 1703 because they missed the 2-year mark, they still have they are still entitled to a suit for damages and other equitable relief under Section 1709 and Section 1711 of the Interstate Land Sales Act.
Your contention is essentially the only thing that they lose, if we accept your argument, is their rescission rights. If they can otherwise prove some damage other than rescission, they're entitled to bring that kind of a claim under 1709.
That's correct for Mr. Baker.
Right, and I understand your argument is that Ms. O'Brien doesn't even get to play because she didn't sign the contract until the building was complete.
That's exactly my argument, sir.
Okay. If we accept your argument, at least as to the interplay between the statute of limitations, the 2-year rescission, and the 3-year period within which to file a lawsuit, does that necessarily require us to conflict with the Engel Holmes case, the 4th District?
The Engel Holmes versus Krasny case? Mm-hmm. No, Judge, not at all. And that was actually dealt with in the Dithart case, which is the Southern District of Florida case. The Engel Holmes versus Krasny case dealt with a 1703B violation. We're dealing here with 1703C violation. 1703B is sort of a buyer's remorse provision, which gives the buyer 7 days in which to rescind the agreement. That particular section does not provide its own statute of limitations. It simply provides you've got 7 days to rescind. It does not go on to say what happens if you are not given that right. Therefore, you have to look to the more general provision in 1709 for the right and 1711 for the statute of limitations, which gives you the 3-year statute of limitations to bring a 1703B claim. Our case is different. In 1703C, it's more specific. 1703C provides the substantive right to a property report, and if it is not, and also to certain contractual provisions. And if it is not given, it provides its remedy of revocation and its own statute of limitations of 2 years. So our position is absolutely does not require this court to conflict with Engel Holmes versus Krasny. It would be perfectly in line with it, and that is the reasoning which has actually been adopted by the Taylor Court and the Midas Court. I'd like to reserve my remaining time for rebuttal if there are no further questions.
All right. You've got about 7 1/4 minutes.
May it please the Court. John L. Urban of Urban Tier, Feder and Jackson on behalf of the appellees, Shane BAKER-CHAPUT and Christine O'Brien. I'd like to just take a step back for a moment and talk about the whole intent of ILSA and the Samara decision the Florida Supreme Court set forth that, and this is also backed by other federal appellate courts, the Florida Supreme Court said that ILSA should be liberally construed in favor of broad coverage to effectuate its remedial purpose. And that purpose is to protect purchasers, not to protect developers. It's to protect purchasers.
Well, I don't disagree that that's the purpose. Let's just focus for just a minute on the narrow question of whether Ms. O'Brien is entitled. When she enters into the contract after the building has been completed, why would even a liberal interpretation of the contract, of the statute rather, need to embrace her when she's not within the group that they're seeking to protect, since the building's already built?
Two reasons. First of all, I think it's Winter versus Hollingsworth. The appellate court there clearly said the ILSA analysis is limited to the date the contract is signed. Was there an unconditional commitment? Was ILSA complied with? It doesn't matter what happens afterwards. There's even cases where a property report was given a week after the contract was signed, and the court still said no. It is on the date of signing. Also, as the opposing counsel pointed out,
the contract that was submitted didn't have her signature on it.
No, but as opposing counsel pointed out, it was an addendum signed relating back to the date of the signing. It was not a separate agreement. It was part of this contract signed on a pre-construction date. There's no dispute here. So, again, I believe that is somewhat of a red herring, this whole issue of Ms. O'Brien. My law firm represents both of the plaintiffs. Mr. Baker was the original purchaser and plaintiff. She was added by addendum, and to appease opposing counsel, we went ahead and added her as a party, and the court went ahead then reset the hearing on the
Did it
motion.
work? Were they appeased?
I'm sorry? And
Apparently you didn't make him as happy as you needed to.
so, but I hope that answers the court's question. And certainly we
What
can't
did
have one.
maybe I need to look at the language of the addendum. I assume, did they sign the addendum?
Yes, this was an
And-
addendum
and-
that they wrote.
And did the addendum, is it one of the exhibits in your
I believe
in
it's
your
part of the
appendix?
contract.
Maybe I just need to look at it. I mean, does it specifically say it relates back? And
Well, no, but I believe I believe the law is well settled. And I don't have a copy of the contract in front of me, but it is clearly an addendum to the contract at issue, and it certainly would relate back. And the ILSA analysis is clearly limited to on the date of signing when that contract was entered into.
your contention, I mean, I guess in a nutshell, is that whatever rights he had, she's got.
Absolutely, the purchasers have the right on the date that contract was entered into and an obligation was incurred. That is the law.
Well, the problem I'm having with that, and I mean, I understand the logical appeal, but if Mr. Baker, let's just take Miss O'Brien out of the equation entirely. If Mr. Baker had decided, after the fact that he didn't want to be involved in this, and he had assigned his contract with their consent to me, and the building was built, I mean, he just couldn't close because he didn't have money or, whatever, and I got the dough, and he just assigns his contract to me, and they're fine with that because they want to close. And then I carefully comb through the contract, and I see that Mr. Baker never got a property report to which he was entitled. Under those circumstances, do you think that the purpose of the statute is served by giving me now the subsequent assignee, and I have, presumably no greater and arguably maybe no lesser rights than whatever the assignor had? Is the purpose of the statute well served by letting me now come in and assert an ILSA violation?
Well, first of all, that's obviously an issue of assignment, but I would say arguably, absolutely. The point of ILSA is that a developer gives purchasers, before they sign the contract, a property report so that they can make an informed decision. There's some narrow exemptions. They consciously decided to go with an exemption, which needs to be narrowly construed. They didn't give the property report. They didn't give an unconditional commitment. Absolutely, the rights should extend to the people who are party to the contract, who are the purchasers. But again, I believe it's distinguishable because Ms. O'Brien is a party to the actual contract. She's not an assignor that's stepping into the shoes of Mr. Baker. She is a party to that contract and when it was signed. And secondly, I'm not sure how the court would reconcile Mr. Baker's right then to rescind and then leave out Ms. O'Brien because somehow, well, she signed afterwards, yes, the same contract, but we're going to sort of put a divide between them. And so one of them gets out of it and gets their deposit back and the other doesn't. It just, I think, judicially and logically doesn't make sense for the application of the law.
I agree. It's a messy situation that I don't know how we would resolve it. But how do you address the argument that opposing counsel makes that if that Alabama federal case is a correct interpretation of the interplay of those two things, then your clients lost their right to rescind. But how does that interplay then with your contention that the contract was illusory because it didn't contain an unconditional promise to commence construction within an appropriate pre-sale period?
Well, there's two absolutely separate issues. There's the issue of was ILSA even violated, and I believe that the briefs clearly address that. There's multiple excuses to completing within 2 years, which is what ILSA requires to qualify for the exemption. There's also a limitation of liabilities under the Section 26 of the contract, which says, hey, if we don't believe we get enough contracts in here after 2 years and 30 days, then we can just not build and give you back your money. So I believe the ILSA violation is clear. But I believe the court hit the nail on the head as far as the real issue at heart here is there statutory ILSA rescission right? Can they still avail themselves of that because they didn't rescind until 2 years had passed? And I would say absolutely yes. But I think more importantly, even if this court says, no, we agree that they blew it, well, the bottom line is they still have the equitable and legal rights of rescission damages. And what are their damages but that they just want their deposits back? Exactly what the lower court gave them. But getting back to the issue of the statute of limitations, in Krasner...
But if the statute of limitations specifically puts to rest the right of rescission, but under, I think it's 1709, would arguably give them other legal and equitable remedies. Can you then come in and say, well, okay, under 1703 we've lost our rescission rights, but we've got rescission under 1709 because it talks about other legal and equitable remedies? Or do you have to look for are you entitled to claim any equitable remedy that you want other than rescission?
Not at all. For the simple reason, this is the statutory rescission right. It says right in 1709, other legal or equitable remedies as are fair and the court seems are just. That's exactly what it says. The court applied those remedies. Now, in this case, the court did say, and I believe properly, that they had 3 years. And this is why. And this is exactly why Krasner, the fourth DCA, is exactly on point. There's only 2 provisions in the entire ILSA that say this right has to be mentioned or shall be provided for in the contract. And that is 1703B, which is the 7-day rescission right, and 1703C, which is the 3 years at issue here. The 2-year revocation right at issue here. Those are the only ones. 1703D, which is where Diddy Hart, and I'll get into that in a minute, but another case sort of confused the issues. That one doesn't require that right be mentioned in the contract. So what we have here is a situation where the developer is trying to have his proverbial cake and eat it too. He wants to skip mentioning anything in the contract as statutorily required under ILSA that they have a 2-year right to rescind, and then say, well, yeah, we didn't mention the right, but we still want to use that right, even though it says it shall be provided. That's that one little section, 1703C. So if they didn't avail themselves of that because they didn't tell them about their right as they're statutorily required to, well, we go to 1709 and 1711, which say you have a 3-year right for all ILSA rights. So you can't read...
If your argument is correct, if you were counsel then in the Alabama federal case.
Yes.
If you were representing the prospective buyer who was attempting to rescind, your argument, if I understand it, would have been, okay, Judge, you've ruled that we don't have a remedy under 1703C because we didn't give our rescission notice within 2 years. But under 1709, because we filed suit within 3 years, and that statute allows us legal and equitable remedies, we are entitled to seek rescission there because we're timely under that, and rescission's an equitable remedy. I mean, is that your argument?
Absolutely, Your Honor. In fact, Taylor says that. The Southern Alabama decision says that it only applies to the rescission issues and the other ILSA remedies are still preserved. So I don't think that's...
But 2-year statute of limitation is meaningless then.
Not at all. If they mention it in the contract as they're statutorily required to, and as the legislative history, which is included in the appendix, says that that right must be clearly indicated in the contract or agreement. That's right in the legislative history. And the statute itself says, right at the end, it says, such contract or agreement shall clearly provide this right.
But isn't it up to Congress to provide a penalty? I mean, I can't think of any other situation where maybe there are, you might know, but just off the top of my head, I mean, under normal circumstances, I mean, if you and I have a traffic accident, I don't have to tell you that you've got a 4-year statute of limitations to sue me. You're just assumed to know that. So if Congress intended that there be a penalty if I mean, I agree with you, the statute says you got to put this in the contract. If they don't do it, wasn't it up to Congress to say, and if you don't, here's what happens?
No, for two reasons. Number one, the Congress actually did say, they gave us some legislative history, and they said, and I think this speaks volumes, it says, since the committee believes that a fully informed consumer is essential for minimizing fraudulent sales or reckless investments, several provisions regarding the time allowed to a consumer are being amended. This is the 1980 June 1st Amendment. So then it goes on to say, while retaining the 2-year revocation period for failure to provide the property report, that right must be clearly indicated in the contract or agreement, and a purchaser has a 3rd year in which to sue to enforce that right. So what is the remedy then? If they don't avail themselves, if the developer doesn't avail itself of the 2-year limit versus the 3 years for all of ILSA, by including in the contract, listen, purchaser, you have 2 years to rescind, then why should they be allowed to exercise their rights under 1703C? The default that Congress put in was 1709 and 1711, which states you have 3 years for all of your ILSA rights, equitable, legal, etc., and that 2 years is absolutely limited to where the contract or agreement clearly provides this right.
Did you raise this below?
We certainly, we discussed, yes. I mean, at the hearing, and it's in the transcript, we absolutely talked about the 2 versus 3 years.
Well, I'm not talking about the 2 versus 3 years. There were multiple theories relative to the 2 versus 3 years. Your argument that they didn't put it in the agreement, therefore it's a 3-year statute of limitation, was that raised below?
I believe so. I know we argued, I would say yes. We argued that 1709 and 11 trump 1703C if the developer didn't properly avail itself of that. So I believe the answer is absolutely yes. Maybe not in the words I'm using now, but that issue was absolutely before the court. And the court wrote, no, I believe, I don't think I used the word trump, but it says, I'm going with 1709 and 11 because it trumps 1703C. Because they didn't properly avail themselves of it. I think that's the logical conclusion. And I'd also like to say that the Krasner Court holding is directly on point here. Like I said, it deals with that same failure to notify. And it says, quote, Engel Holmes drafted the contract under contention in this case. Its contract failed to follow the mandates of the law. Yet, it seeks to limit the remedy available to the Krasners, purchasers in that case, to the liquidated damages clause of the contract. This court will not impose such a limitation. Accordingly, the summary judgment of the lower court is affirmed. That's exactly what the Krasner Court holding was, grappling with exactly this issue of the failure to give the notice, to allow a developer in a pro-purchaser, liberally construed, broad coverage statute meant to provide information to consumers, to not provide the statutory 2-year limitation and then limit, though, that same purchaser to it, I think is unjust and absolutely contrary to the entire intent of ILSA. It is meant to give them information. A developer is simply supposed to provide a 20, 30-page property report which lists basic information, selling prices, utilities, where it's located, proximity to medical facilities, food stores, just general information to make an informed decision. They consciously elected not to provide that property report. They knew about ILSA, and they read ILSA. They didn't put in what statutorily required to be put into a contract. And yet they stand before this court and say, please, court, reverse the lower court and give us the 2-year limitation, even though we didn't comply with the statute, which provides clearly in 1709 and 11 that you have 3 years. And I believe that is at the core of this case, really.
You only have that argument if the contract is not illusory, right?
Absolutely, and I would like to touch on that next. There's one other issue, though, on this, that there's a decision out of the 11th Circuit called Sarfati versus Wood-Hawley Associates. And there, I believe, the 11th Circuit exactly addresses this issue. They are dealing in that case with exactly 1703. And in that case, what happened, though, was the cause of action accrued in April of 1980, and the amendment didn't occur until June of 1980, and the court said, sorry, you're stuck under the 2 years. If your cause of action had accrued after June 1st, 1980, you'd have 3 years. And essentially what they're saying, that is exactly under 1703C claim. So they even said there, the 11th Circuit, same analysis, said, geez, you would have had 3 years, and it says, very tellingly, maybe not artfully, but I believe when you read the decision, just like Krasna, it hits this issue right on the head. Sarfati further claimed that Wood-Hawley violated Section 1703C of the Act because the contract for sale did not contain a provision stating that the purchaser had a right to revoke the contract if no property report had been furnished. And then it goes on to just recite 1703C, that such contract agreements shall clearly provide this right. And it goes on to state that because Sarfati's cause of action accrued in April of 1980, they couldn't avail themselves of the new statute of limitations under 1711 because the cause of action accrued before June 1st, 1980. But I believe right there, Your Honors, as a court analyzed this exact issue, they're almost throwing to the wind saying, well, of course they would have 3 years because they didn't give them the right in the contract, so they would have 3 years, but they don't because they didn't get under the new amendment, not because they're limited under 1703C. They didn't state the right, so they would have had 3 years if their cause of action had accrued after the amendments, which was the amendment from 2 to 3 year statute of limitations for all the ILSA rights. So I believe those are directly on point. I also would just like to quickly address Taylor. Again, it's from the Southern District of Alabama. It is what caused Midas. I spoke to Counsel in Midas yesterday. He's filed a motion for reconsideration, which is being considered by the court. It also exclusively relies on the Taylor opinion. Taylor actually cites Krasna, but in the Taylor opinion, it misconstrues Krasna. It says, Krasna applied the doctrine of waiver to extend the 2-year statutory period indefinitely in the absence of notice. That's not what Krasna says. It says if you don't give notice, you're not stuck with the 2 years. You get the full 3 because the developer has a requirement to put that in the contract. That's what it stands for.
What's the difference?
I'm sorry?
What's the difference?
What's the difference between what?
What's the difference between an indefinite extension and a 3-year extension? Why is
well,
that?
Indefinite seems to indicate, the court just said, well, if they don't tell you only have 2 years, well, then you must have forever. That's not what it says. It says, no, then you have the 1709, 1711 limitation of 3 years. So, again, it sort of disposes of Krasna, which addressed this exact issue, and then goes ahead and I believe, and it even says in that Taylor decision that there's a paucity of authority presented by the parties and a dearth of helpful case law. That's not true. There was Krasna, there was Sarfati, and those decisions are directly on point. And those decisions, according to the Samara decision of the Florida Supreme Court, they talk about what the law is in Florida in the application of ILSA. And I know I'm almost out of time, but I believe that the brief adequately addresses the issue that ILSA was clearly violated. I believe the 2 versus 3 year statute of limitations issue is really at heart here as to the statutory rescission right. But if I could just have 1 more minute to sort of sum it up.
All right.
Even if this court agrees with Plaza Court's argument that the protections of 1703C have been lost to the appellees because the 2 years had passed, but they obviously did sue within 3, the exact same outcome and results are provided for by 15 U.S.C. 1709 and 1711. Accordingly, the appellees respectfully maintain that this court can absolutely affirm the lower court's decision based on the equitable and legal remedies that are available. The only issue really here is the statutory ILSA rescission right limited to 2 years? And I would say clearly not, and that Krasna and Sarfati say so. But again, the decision should still be affirmed. The Tipsy Coachman Doctrine gives this court that discretion, and I believe it absolutely should exercise it. Thank you.
If I can just turn my attention back to just O'Brien for a moment. As the court was addressing with Mr. Urban, the act was not intended to apply to someone like Ms. O'Brien. In April 2007, when she signed that special addendum, at that point, she had the absolute ability to say, you know what, this is not really what I wanted to do, and have zero liability on the contract. She could have stepped back and said, I want no part of this at that point. And that is why a sale of an improved piece of property absolutely doesn't apply to this type of purchaser that comes in after the construction is complete.
Well, but if she had, forget that she joins in. Let's say she'd taken an assignment. Doesn't the assignee get whatever rights the assignor had? And if the assignor, in my hypo, if the assignor had a right to rescind, then the assignee would have a right to rescind, and likewise, if he didn't, he wouldn't.
That seems to be more of a transfer of a chosen action than what we have in this case. In this case,
this isn't a chosen action; it's just a contractual right, but. You probably don't want to waste your time on that point.
What I really would like to address very quickly is the appellee's argument that the failure to provide the 2-year notice in writing somehow extends the period either indefinitely or to 3 years. Simply not the case.
Let me ask this as a preliminary to that, because I'd like you to address that issue as well. Was that raised below?
No, sir, it was not. The appellees simply said at the motion, for the first time at the hearing on the motion for summary judgment, now the contract clearly doesn't provide for the right of rescission. They left that out of it. So we're dealing right now with Section 1703C. That is the sole mention of any, to the extent that is an extension argument, that's the sole mention of it that I could find. Now, to the substance of that argument, even though we've cited in the brief that we believe it was waived for failure to raise it below, to the substance of the argument, that very issue is dealt with in the Middle District Court case, the December 17, 2008 opinion in Midas, which followed the reasoning of Taylor, which said that the failure to give the 2-year notice in the contract does not extend the 2-year statute of limitations. And I think this is further supported by the legislative history that Mr. Urban was talking about. If the legislature wanted to...
Well, you would agree, though, that, you're getting back to the Judge Conway opinion, that's not binding upon this court.
I understand. I understand that. But looking back at the legislative history, if the legislature had wanted to provide for an extended statute of limitations period, if you failed to give the 2-year right of rescission, they clearly knew how to do it in a consumer protection statute. If you look at Truth in Lending Act, in that act there's a 3-day right of rescission, and if you fail to tell the consumer about that right in writing, then the consumer has 3 years. So the legislature did it in that consumer protection statute. They clearly know how to write it in if they want to. They didn't do it here.
What is the remedy for failure to comply with that provision?
For the failure to comply with...
There's a clear provision that says you shall give clear notice. And if that's not complied with, what's the remedy?
It may not be the remedy that the purchaser wants, but they are still left with their other equitable and damage remedies in 1709. Yes,
which is the argument he just made, isn't it? What am I missing?
He's making the argument that rescission is also available under 1709.
Your argument is that he's entitled to everything but rescission.
Exactly. Everything but
whatever
rescission.
That might be.
Correct. And it simply would not make any sense to for the legislature to provide a 2-year provision in 1703C, but then give it back with the other hand in 1709. That was not intended because, as Judge Cohen reference, that would render Section 1703C completely meaningless and superfluous. It doesn't even need to be there. And general rules of statutory construction provide that if there's a way to harmonize the statutes, that should be done rather than to render one completely meaningless.
Why doesn't the 2-year limitation apply where notice is given and something else apply where notice isn't given?
I'm sorry, I don't understand the question.
C requires that the contract clearly provide for the right. And
yes.
if the contract does provide for the right, then there's a 2-year limitation on the right to revoke, is there not?
Yes.
But if the contract does not provide the right, then there's a violation that is that is answerable under 1709. Is there not? I mean, you've already said that. But for some reason, you seem to think that revocation magically disappears. I just don't get that argument.
There's nowhere within the plain language of the statute that provides if you fail to revoke within your 2-year period, that you are somehow handed back the right of revocation under 1709.
But isn't it a matter of common sense that this provision applies and there's a 2-year limitation on your right to revoke if you are given notice that you have a 2-year limitation on your right to revoke? But if you fail to include that provision in the contract, then you can't rely on the 2-year limitation on the right to revoke. It's essentially an estoppel, isn't it? Is it not?
Well, that's not the reasoning or the decision reached by the Midas Court in the Middle District or by the Taylor Court.
Well, the Midas Court seems to treat this as a statute of limitations, which it plainly is not.
It is not a statute of limitations. It is
Doesn't the Midas Court treat it as a statute of limitations?
It does treat it as a statute of limitations.
And that's clearly wrong. You don't even contend that, do you?
No, we're treating it as an absolute 2-year revocation period, which is a prerequisite to being entitled to the 3-year statute of limitations.
But it's not a statute of limitations. It's a limitation on a right of revocation, and I don't understand how your 2-year limitation on your right of revocation can apply when the statute itself says that in order for it to apply, you have to clearly put it in the contract, and if you don't put it in the contract, then I fail to see how there's any remedy for that violation.
Well, I can only turn to the legislature, the legislative history for it. They have not indicated any. Made any indication that the failure to provide the right would give the purchaser any extended period of time.
It doesn't appear that the general master ruling was based upon the failure to include the 2-year provision in the purchase agreement. Is that correct?
That's correct, Judge Cohen, because it's our contention that it was not raised below. I'm out of time. If there are no further questions, we respectfully request the Court reverse the summary judgment.
Thank you.
Thank you, Counsel.
Thank you.
This was well argued and well briefed.